and do an investigation and monitor for the conditions there to make sure that people that reside there or receive services there are not being abused and neglected. Excuse me, we're governed by a 15-member board, and we have a 9-member PAMI Advisory Council. This is our mental health advisory council. They advise the board on things that are happening in Iowa that are very particular to mental health and things that the board needs to be aware of. If I can go for it. Okay, so our mission is we are involved in advocating for justice, advancing human and legal rights, and protecting Iowans with disabilities. You can go for it. We have a vision. So this is if we had control over the world, how we'd want the world to be. So what all of our work is striving for is to create a changed world where people with disabilities are valued, fully included in their communities, the workplaces, and their schools, where they have equitable access to all opportunities and make their own decisions. That governs every single thing that we do as an agency. You can go for it. We have certain core values that also help govern our advocacy. And these core values, different letters in each core value creates the overall motto for our office, which is creating change. So our core values are civil rights, partnership, empowerment, equal access, justice, inclusion, intersectionality, dignity, and change. Those are values that when we think about what we're doing as an agency and whether we can take this particular person's request for help or this person's, we're always thinking about which case furthers those values more. So it governs what we're looking at doing. You can go for it. Okay, so some things that we provide, and these you can just kind of hit because it goes. So we provide education and empowerment to on a variety of different disability rights topics. We do a lot of work with individual legal advocacy. We do a lot of outreach and training. We do a lot of work across the state of investigating and monitoring facilities. And we look at how we can be involved in changing systems that are either not working for Iowans with disabilities or creating barriers for Iowans with disabilities. We provide technical assistance. So if anyone here had questions about the ADA, we could answer those questions as long as it wasn't something specific to you, but you just wanted to know, we could help you. And then we do a lot of work with people that are receiving benefits on how they can continue receiving those benefits, but also work. And then we have a representative payee unit that investigates organizations that serve as someone's representative payee to make sure that that organization is not stealing their money or creating fiscal mismanagement. You can keep going. And if there's a question in the chat, can you let me know? Because I can't see that. Thank you. Okay. So as I said, we provide free assistance. We receive federal grants that allow us to be able to do this free of charge for Iowans with disabilities. These are the requirements to be eligible for assistance. You have to be a resident of Iowa. We do not have an income limit. We do not have an age limit. We do not have an immigration status requirement, but we do have some very specific requirements. You have to have a disability, which is defined very broadly, as you're going to learn in a couple of minutes here. And you have to have an issue that you're calling about that is disability rights related. Now, a lot of people call and they don't quite understand this nexus because when you're a person with a disability, everything pertains to your disability. We all understand this, right? But what we're talking about here is something, a disability related rights violation that we have a law that we can use to help address that issue. So if you call and you're going through a divorce and you're a person with a disability, there's no federal disability divorce law, right? So it's not something we can help versus calling with an employment issue. There's a federal disability rights law that we have access to. So that's kind of how we make that distinction on, is it a disability rights related issue or not? And then the issue that the person is calling to ask for help about has to fit into one of our 3 areas of focus. Okay, you can go forward.
I have a question. If like you're a college student and you're in Iowa, what, 9 months out of the year, does that count as being a resident? Okay.
Yeah, because you're here and probably if you're calling about an issue you're having with your school in Iowa. So yeah.
Okay.
Great question. Yeah, that would cover.
Okay.
Okay, so these are just some current things that we're working on. I thought you might be interested in. We do a lot of work, with making sure that students with disabilities, in particular behavioral disabilities and mental health, disabilities remain in school. Schools have a tendency to push students with disabilities out in a lot of different ways. This doesn't happen as much in higher education, so it's more of a secondary education issue. It does occur in higher ed, but to a lesser degree. Right now we have a class action lawsuit on the lack of a children's mental health system in Iowa. That's something we've been working on for a couple of years now. We have done a lot of work in COVID times about equal access to COVID-19 vaccines. When the vaccines first came out, the only way to be able to get them, maybe you might remember this, was to sign up online. Those online systems were not accessible. So there are lots of problems with getting access to the vaccines. Managed care and Medicaid. Iowa switched to managed care, I think about 7 years ago. And we've done a lot of work within managed care since that time, trying to address the issues that are occurring within that system for Iowans with disabilities. A lot of work on Medicaid and making sure that people have access to the services and supports they need through Medicaid to remain living in the community. And as I said, abuse and neglect of residents in facilities, we do quite a bit of work with that. We'll keep going. Okay, so this is the history. I have like maybe 4 or 5 slides on history. I know we didn't talk about that. Is that?
Yeah, no, that's okay. Yeah.
Okay. I think it's always helpful to know what our history is, even though it's a hard history. I'll be honest. It's not something where we were treated well, let's just say. So the history of how both Iowans and any person with a disability in the United States or abroad has been treated is shameful. That we were treated as objects of shame, pitied, fear, ridiculed. Generally speaking, certainly Iowans with disabilities and others living in other states spent most of the early part of the history living in institutions. There wasn't really a home community-based waiver system or supports in the community. The prevailing notion at the time, if you had a child with a disability, was that the best care for that child was in an institution. And that's what doctors would actually say to the parents that have the child. And now we think of it very differently, but back then that was considered best care. So institutionalization, horrible history of sterilizing people without their knowledge, without their consent, right? I came from Kansas most recently to moving to Iowa. Kansas had sterilizations that were legal up into the mid-60s. Iowa wasn't that far behind, so pretty bad, right? There were no federal rights at all for education or equal access to anything. So consequently, there was children being turned away from schools, saying, no, go away, you can't come in here and be educated. People were hidden from community. They were abused and neglected, had no ability to vote, to marry. All the rights that we take for granted today were not available. Every single state segregated individuals with mental health disabilities. And epilepsy, for some reason, was very concerning historically. They're excluded from public schools, denied the ability to vote, to get a job, to participate in the community. And then the states fueled and this fear. They wanted people in the public to report individuals that they considered feeble and segregate them into institutions. And the term feeble-minded was used very, very frequently. There was a real campaign to make it appear that individuals with disabilities were not quite human. They were something else, which could justify this level of discrimination and isolation. I'm gonna keep going. So this is just kind of some things that I thought might be interesting in terms of time frame, because none of this was really all that long ago. So 1967, we had 200,000 individuals with disabilities living in state institutions. That's a lot. That's almost 250,000 people. Prior to 1970, there was no law that required public schools to educate students. So it was very possible that, during kindergarten roundup, a principal or a teacher would look at a kid and decide that kid couldn't be in school and would tell the parent, your kid's not educable. Go take that child up to that nice white house on the hill. That's where they should be, right? And there's no way to fight that because there's no law that pertained and protected kids' rights at that time. 1920 to 1970s was the eugenics movement. This is where people with disabilities were called subhuman creatures, waste products, or were considered responsible for both poverty and crime. And this was during the sterilization movement. So that just hundreds and hundreds of people were sterilized in this last 40 years. And if you think about 1970, it's just not that long ago. So this was happening for a very significant period of time. We'll keep going. This one is particularly upsetting because it was really recently this happened. There were a series of ugly laws, and this actually prohibited individuals with physical disabilities to appear in public. And what's on the slide there is the exact law. It says no person who is diseased, maimed, mutilated, or any way deformed so as to be unsightly or disgusting object shall be allowed in or on the public ways or other public places. The fine of $50 for each offense. This particular law is from Chicago and was enforced as recently as 1974. So 50 years ago, right? It's just sort of hard to imagine. But many states outlawed rights of individuals with physical disabilities to enter contracts. Now, most people don't think of marriage exactly as a contract, but it actually is. It's a legal contract. So people in those states with a physical disability could not get married. Keep going. Okay, so that's the horrible history, right?
Mm-hmm.
So that's awful. But what arose from that was a strong, powerful group of disability rights heroes that created an advocacy movement unlike any that we've seen, right? With their advocacy, many federal disability rights laws have been enacted and have really changed the history of what has occurred. Well, it hasn't changed history, but it's changed us going forward. So this started really with the Americans with Disabilities Act was the big one. So in 1990, there was a Wheels of Justice campaign in Washington, D.C., where hundreds of individuals came to DC to support the ADA. There was a lot of pushback against the ADA. There was an infight amongst the disability community. So back in this period of time, there was a real ongoing debate about which disability was the true disability, right? And in Iowa, this is still happening. We're still fighting to this day about whose disability is the right disability or the most important disability and what should we pay attention to. To get the ADA passed, that discussion had to stop. There was one point in this Wheels of Justice campaign where there was discussion about the ADA could be passed successfully. They had enough support from Congress if only the mental health part of the protection was dropped. And the group of activists that were there came together, talked about it, and said, no, we're all for one. Every disability needs to be included in this. So because of that, we now have protections for mental health within the ADA. But if they had said no, then probably to this day, we wouldn't have those kinds of protections. So, but they occupied the Capitol, they had a huge protest, many arrests occurred. This was 1999, but this had been going on for years. So let's go forward on the next one. So this protest became referred to as called the Capitol Crawl. And this is a slide I'm going to want to show in a couple of minutes or two. Okay. But this was a protest, March 13th, 1990, 1,000 people stormed into DC. They marched from the White House over to Congress. And I don't know if anyone's been to Congress, but when you get there, the only way to get into Congress is to walk up 60 flights of steps, right? It's just huge. So when they got there, many of the early disability rights advocates used wheelchairs for mobility. They were all survivors from polio. And so they were there and they're like, well, what are we gonna do now, right? So those that could left their wheelchairs behind and crawled up the steps. And this created quite a controversy. We'll go to the next slide. So if you can get that to play, this is a minute or two video of that crawl.
I mean, I remember when we were trying to get the ADA passed, and I need to climb the steps. I want to climb the steps, and Wade said, "Go for it." So I got out of my wheelchair and I started climbing.
Oh, can you?
I have
Well, the next thing I know, I've
they can
got
see it.
Oh, okay,
50
good.
cameras
All right,
on
good,
me, and
good.
I've got mics all over me, and it's like the hottest day of, you know, the month of March, and I'm just, I mean, and I'm like, you know, I'm like 8, 9 years old, and I'm going, water, 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 I need water. And, you know, I've got the little pamphlet in the back of my pocket that we're supposed to hand over to the politicians to get the ADA passed, and they say that that it was the image of me climbing those steps that you know, was the final decision to get the ADA passed. And I mean, I had to do it.
Thank you. I'm glad that worked. So that was the crawl that changed Congress, and that's a theme you'll find if you study how we have come to have different federal disability rights laws. Disability advocates had to shame politicians to get this done. It's just throughout history, but let's go past that one. So the congressional findings, anytime Congress is looking at a law, they always do a study about what's kind of the state of the state. So this is just some of what the findings were when the ADA was out in front of Congress. They found consistently denials of educational opportunities, lack of access to public buildings and bathrooms, absence of accessible transportation, a very scary and alarming rate of poverty, huge educational gaps, and a life of social isolation. And then those on the slide are some of the statistics that were in this study. The one that, you know, I think some of them you probably could kind of understand based on those findings, but the ones I want to really call your attention to is that kind of in the middle, it says 2/3 of individuals with disabilities had not attended a movie or a sporting event in the past year. Now, just think of what you do for fun, right? You're sitting in your house by yourself, essentially is what they found, right? But if you think about before the ADA, there was no accessible transportation, buildings were not accessible, events were not required to be accessible. So it might have been actually impossible to leave and go and be a part of the things that occur in public. The other one that I always am struck by is that I think it says 13% of individuals with disabilities never, and they mean never in your entire life, went to a grocery store.
Wow.
Right? Now that's a lot of people not going to a store. So just like the basic, how we take care of ourselves, people were not able to do before the ADA. Let's go to the next slide. Okay, so this is kind of going back in time a little bit, but these are the congressional hearings from 1975. This was the right to social education. It's the law before the IDEA, but this eventually turned into the IDEA. And so the findings here were that millions of children with disabilities were excluded from schools. So, and then 3.5 million children with disabilities didn't receive education appropriate to their needs. And again, there was no law requiring this at the time, but schools were not doing it. There was 1 million children that had no education at all. School districts had special education programs, but 7 states educated less than 20% of known children with disabilities. There was no law requiring schools to identify kids that might need access to special education at that time. And 19 states were educating about 1/3 of the students that needed special education. 17 states provide education at 50%, of the children with disabilities. So essentially very, very, very low education rate, right? And what the findings were is that the districts had no money to pay for it. So when the federal law came, funding was provided from the federal government for our special education now. So the reason I think it's important to go through and know what the history is that even though we have these federal disability rights laws now that protect us, there are still notions in our public and perceptions about disability and what disability means and how people with disability should act and where they should live that still exists, that are historical in nature. And so it's important to know where we came from, what rights we have, and how to address people that say things like, I think anyone with a disability should live in an institution. That's the best place for them, right? If you don't know the history and why we moved away from that and the rights you have to live in a community, that's a harder conversation to have. Okay, so that slide that was on before was really just the numbers of people with disabilities. Disability is the largest minority group in the United States and in the world. And so the numbers were there for you to look at. What the Americans with Disabilities Act did was significant. It changed society. It changed every single aspect of how we live today and how we function. It created rights for people with disabilities that did not exist before. So a right to ask for accommodations, a right to have equal access to facilities, to education, to events, right? None of that was present before. Said that you cannot be discriminated against based on a disability, again, brand new. And it changed from this notion that, oh, we'll include you because it's the right thing to do, it's the kind thing to do, or we're going to take pity on a person and make sure they're included, right? That is not what the ADA is. The ADA is a federal right that you have to be included. So it created a class that's very powerful. Let's keep going. Okay, so the ADA, signed by President Bush, July 26, 1990, comprehensive civil rights law. Congress had these very specific goals in mind when they passed it. So they wanted individuals with disabilities to have equal opportunity, full participation, independent living, and
Okay.
self-sufficiency.
Bye.
We have somebody unmuted. Sorry.
Okay, is there a question?
No, I think it was an accident.
Okay. So those were the goals that Congress had, and Congress really intended this to be a comprehensive civil rights law. So they had 5 different titles of the ADA. The one that most people talk about all the time is employment, that's Title I. But Title II is public services, so local services, government services are included in public services. Title III is public accommodations. That I like to call it all the fun stuff. It's anywhere the public is invited to go. That Title III applies to that. And telecommunications was Title IV. This was a big issue when the ADA was passed for individuals that were deaf. There was no way to have accessible phones, right? So the telecommunications component of this required a video relay service to be established. So I don't think that that's used as much now as it was back then, but that was super important at the time. And then the 5th title is one of retaliation. So if you file a claim and you get retaliated against, that also violates the ADA. So what's below there is, again, another congressional finding that I always think is important to know, kind of like why was this so upsetting to Congress? And it was so upsetting because they found essentially that people with disabilities were being discriminated against and excluded from society. And they said, no, that is wrong, and we're going to change it. So a really progressive law. Okay, so this guarantees all individuals the right to non-discrimination, equal opportunity, and program access. I might have kind of already summarized this briefly, but Title I, if you're a covered entity, that means you cannot discriminate against a qualified individual with a disability, and you have to provide a reasonable workplace accommodations. So being a covered entity means that you have 15 or more employees. So most people are covered under Title I. There might, if you're not covered by, because you only have, let's say, 2 or 3 employees, there might be a state law
Mhm.
that has less employees that would be covered.
Okay.
Title II, state and local government services, public accommodations, and commercial facilities. So we have a service animal requirement. I just wanted to kind of add that in, that for service animals, as part of the ADA, you have the right as a person with a disability to bring a service animal with you into a public space. Keep going. Okay. So requirements of ADA, it requires reasonable accommodations to qualified employees. Requires public and private entities to provide equal access to goods, services, and activities. There are architectural standards that have been developed for new construction that you have to comply with, and any kind of substantial renovation construction. These are probably, I'd say, a 200-page document,
Mhm.
extremely technical, written for architects and contractors. But if you ever really want to know what all is included in making a bathroom accessible, you can pull it up. It'll tell you everything that has to be in for the bathroom to meet the standards. Public transportation has to be accessible. You know, again, before the ADA, there was no public accessible transportation. So again, the inability to travel was a real issue. And then the relay service that we talked about already. So who's protected under the ADA? We keep talking about individuals with disabilities. Well, not all individuals with disabilities are protected by every title. You have to be what's called a qualified individual with a disability. And those are people that are protected under the ADA. So the first part of that is, what is a disability under the ADA? That is a person that has either a physical or mental impairment that substantially limits a major life activity. A physical or mental impairment is defined in the ADA, and let's go forward and talk about those. The reason I want to point this out is that many people, when I tell you it's physical or mental impairment, do not understand that mental impairment includes mental health.
Mhm.
And I want to make sure everyone knows that. I've done trainings for so many years thinking that people understood that mental health was included. And I found out during COVID that people did not understand that mental health was a covered impairment under the ADA. So that is like a significant thing to know, especially during COVID, because there were so many new people that were experiencing mental health issues for the very first time. But a physical impairment is lots of different things. I think most people understand everything that could possibly be a physical impairment. But mental is a little bit more confusing. It includes both mental, psychological conditions, and also intellectual and developmental disabilities, learning disabilities, emotional, and mental health. So it's a larger category. Let's keep going. So when the ADA was initially passed, people started filing complaints and lawsuits for being discriminated against. And when those reached up into the courts, the court system started throwing those cases out, saying that the person who was bringing the case had failed to establish that they were a person with a disability entitled to bring the case. Because the courts were interpreting that definition that we just looked at very strongly to say that your disability does not substantially limit a major life activity. That's what they kept saying. So major life activities are things that we do all day long to kind of take care of ourselves. So I'm doing lots of them right now. I'm moving, I'm thinking, I'm digesting my lunch. You both are listening to me, and people on Zoom are listening to me and processing what I'm saying. You know, you probably slept hopefully last night, you had some food. All of those are major life activities. So to have a substantial limitation in any one of those, back before the ADA was amended, was considered to be a very high limitation. And so the court said, nope, this isn't significant, and started throwing it out. So Congress came back in 2008 and amended the ADA to make it very clear that they wanted disability to be considered extremely broadly. And they said, we're going to give you some examples, courts, of things that we think by the nature of these different impairments, that a substantial major life activity is being implicated. So there are deafness, blindness, etc. You can kind of see here, they did add in major depressive disorder, bipolar disorder, post-traumatic stress disorder, OCD and schizophrenia. So this is about 20 impairments here. This is not the end of the list for sure. I've done display work almost 20 years now, and I'd say at least once a month, I work with someone that has a disability that I don't know what it is, and I have to go research it because it's extremely, extremely broad consideration and broad definition. Okay, so that's the first one, right? That's the way that most people will establish that they have a disability is by saying through medical documentation or an apparent disability that they have a physical or mental impairment that substantially limits one or more major life activities. There are two other ways to establish disability under the ADA. The second is that you have a record of having a physical or mental impairment that substantially limits one or more major life activities. Now, that might not make any sense to anyone here or on Zoom, but think about the person that's had cancer who's gone into remission, right? They will have always had a disability under the ADA because the cells that changed, that created the cancer, will have always been there. They're always going to have a history of that. Even if they go into remission, they will still have a history of that. Same with lots of other major health conditions that you might go into remission or recover from, you'll still have that history. What that gives you then is the ability to claim protection under the ADA and also to ask for an accommodation, even if your disability is in remission, right? So the kind of the big example I'll give you here is like, let's say you've had cancer, you've gone into remission, but to stay in remission, you have to have ongoing treatment. Let's say that treatment's in another state and you have to take 2 days every month off to go and have that treatment. You can, under the ADA, ask for that leave as an accommodation to protect your job to go get that treatment to stay in remission. So those are both important ways to establish disability, and both 1 and 2, you can ask for an accommodation. Number 3 is an individual that's regarded as having an impairment. Now, this is different. You cannot, in this category, ask for an accommodation, but you can file a complaint saying you have been treated differently for being perceived as having a disability. This is a very low standard of proof, and there's a lot of complaints to get filed on this. So what it means is you're regarded as having an impairment, that you may or may not actually have the impairment, but you're being treated differently because of perceived impairment. This is something that is not a minor or transitory, so something that's less than 6 months. So what you might imagine, like, let's say someone has, speaks maybe a little differently than other people. Their boss maybe is perceiving that they have a speech impairment or some kind of disability. The person may or may not, right? And let's say the boss says in their head, I can't have this person communicating with people, they're too hard to understand. And they shift the person to a different job that has a lower pay. That's being treated differently because of perceived impairment. That person hasn't disclosed that they have a disability or asked for an accommodation. So that is, again, that would be something the person could file a complaint on, but not ask for an accommodation. So within the ADA, there's also protections for individuals that have a close association with the individual with a disability. So imagine partner, child, right? Good friend that you're helping advocate for an accommodation. All of those individuals are protected from retaliation, but not able to ask for an accommodation. The accommodations under the ADA are for the person with the disability, not the partner. And then if you file a complaint or ask for an accommodation, and then short after that happens, you feel like you've been retaliated against, you can file a complaint. That would be a violation. Retaliation is pretty hard to establish, but the most clear example is you ask for an accommodation, you're working the accommodation, and then you're fired, right? That may or may not be retaliation, but that certainly feels like it might be, right? Okay, let's go on. Okay, so that's having a disability, and then you're qualified. The qualified part of that is important. This example is for work. So you're a qualified individual with a disability, able to ask for an accommodation for work if you meet number one, and you're qualified to perform the essential functions of the job with or without reasonable accommodations. So that might mean a variety of things. It might mean, you know, if you need a certain type of degree, a certain certificate, a certain skill set, that all of those would be essential functions. Okay. So Title I is reasonable workplace accommodations. It is a modification or an adjustment to the job, the work environment, or the way things are usually done in the hiring process. So there's different kinds of accommodations depending on where you're at in the job process that you can ask for. And the purpose of the accommodations are to enable an individual with a disability to have an equal opportunity, not only to get the job, but to successfully perform all of the essential job functions of that position. So these are kind of some of the types of different kinds of accommodations. Each workplace accommodation is constructed on a case-by-case basis. So there is no one accommodation based on a certain kind of job and a certain kind of disability. You have to look at how the disability impacts that person's ability to do that particular job, right? But some of them can be, some really common accommodations can be changes to workplace policy, a procedure, or practice. Can be a physical change to a workspace. So you might need to have a private space. You might need to have a remote work situation instead of being in an office. And there's lots of different kinds of office equipment. So sit-stand desks are one that used to be really popular. A request, Dragon Naturally Speaking, so software for screen readers, office chairs, different kinds of laptops, etc. You kind of, the world is open when it comes to the different kinds of office equipment that exists. That's helpful. You can also ask for leave as an accommodation. Leave under the ADA is unpaid leave. It's always unpaid, but if you have accrued leave built up, you can ask for that. So that can be a continuous leave, or it could be intermittent leave. So like I need potentially a day a week because of my disability. You can also have a change in your schedule. So let's say you're working full-time. You could say, I need to work part-time for some period of time for disability-related reasons, or I need to have a flexible schedule, or I need to come in at 10:30 instead of 9. All of those are accommodations that can be asked for. A lot of times people don't know what to ask for, and a good place to start is with your medical and mental health professionals, and also the job accommodation network. Yeah.
Do these apply to parents of children with disabilities? In other words, if I need to take time to get my kid to a medical.
No,
Okay.
this would not, but potentially the Family Medical Leave Act might. If you're taking time to care for a child or someone that lives with you, you could ask for leave under the FMLA if you're eligible. But great question. Okay, let's keep going. Okay, so that's workplace accommodations, right? So the ADA gives you the ability to ask for an accommodation to apply for a job, to interview for a job, or to do the essential job functions once you're hired. There's also academic accommodations. This is under the ADA Title II and 504 of the Rehabilitation Act. So the Rehab Act was actually the very first ever federal disability rights law, but it only applied to federal agencies. So it's not something that I think is familiar to the public as the ADA, because the ADA applies much more broadly. But between these two laws, as a student, you have the right to ask for academic accommodations. And what is required is that students are provided, the terminology is slightly different here, is appropriate academic adjustments and auxiliary aids and services to afford the student with a disability an equal opportunity to participate in the school's programs. But the process is very much the same. It's if you have a disability and you need an accommodation or an academic adjustment so that you can have equal access to your classes, then you can ask for that through the probably the Students with Disabilities Office on campus. Keep going. So some of the examples here for academic adjustments. And again, I want to say this is not an exhaustive list, it's just kind of some examples to think about, but modifications to academic requirements. Some schools have a requirement that everyone take 3 classes of math, let's say, right? Some people might not be able to meet that requirement because of a disability. You could ask to have that adjusted to take maybe logic or something else that would meet that kind of academic rigor, but wouldn't be math specific. Extended time for testing, a reduced course load. Most schools have a requirement that students have to take at least, I think 12, 9, something, some minimum course load, right? For some students with disabilities, that is not possible, but you could ask to have a reduced course load. Substituting one course for another, priority registration. I don't know if this is an issue anymore with online registration, but if it is, you could ask to register before registration actually opens up, if you would need to. And a note taker. I'll keep going.
I have a question. Hopefully I can remember them. We have run into the question of like, is it just academic things that need accommodations, or do like social events that the school provides? Okay.
Yeah, no, the answer is no, it's both.
Okay.
It's both, yeah. So recording devices, you can ask to record a lecture, American Sign Language, auxiliary aids and services. So this could be a screen reader, voice recognition, or other software or hardware, textbook, note taker, et cetera, et cetera, et cetera, right? So kind of, again, it's an open inquiry of what might help that student academically have equal access. That's the important thing. All of this goes back to what is required for equal access. But there are some things that are not required that I do think it's important to know, because students sometimes ask for these things and then are very, very upset when they can't happen, right? So it is not required to lower or substantially modify any essential requirement for graduation or your degree. The school gets to set that. It's kind of like in the employment world. The employer gets to set what the job duties are. You can't change those. Those are the job duties. These are the degree requirements. Accommodations allow you to get equal access to both those things, but you cannot ask to change them. You also cannot make a modification, or not required to make a modification or adjustment that fundamentally alters a course activity or degree requirement, or something that result in an undue financial or administrative burden. So undue financial is just cost too much money, right? Let's say the request is for me to be in this classroom, I need to have a full-time attendant care worker with me the whole day I'm on campus. Well, that is not required to be provided, right? That's probably cost prohibitive, but also an administrative burden. So that's not going to be required. Fundamentally alter a course or activity. Let's say you have a course that's going to occur outside. Let's say it's one of the gym courses, right? And the course is swimming. We're going to teach you to learn to swim. Okay. And your accommodation request is, I can't possibly get in the water. I will swim, but I need to do it on land. You could try and argue that doesn't fundamentally alter the course. You could still learn to swim, maybe, but could you outside of water? So that might be a fundamental alteration, maybe. Those are rare, I would say, that things fundamentally alter a course or activity. Extremely rare, but they do occur from time to time. Let's keep going. Okay. I did want to talk a little bit about disclosure of disability. You don't, as a person with a disability, ever have to disclose a disability unless you're going to ask for an accommodation. And so I have worked with a lot of people over my years that do not want to ask for an accommodation for work or whatever, for school, to attend an event, to attend a club, because they're very concerned about going through that process and about making that disclosure. So, you know, unless you need that accommodation, there's no requirement under the law that you do it. But sometimes people, both employees and students, feel differently about their disability. They feel empowered about their disability and they want to be their authentic self, and they will disclose it. Whether they need to or not, they don't care, right? That is part of their identity. They're proud of it and they share it. And the law is fine with disclosing or not disclosing. Like there's no requirement, as I said, under the ADA or 504 to disclose unless you're going to need an accommodation. So essentially you have to kind of think through what might I need? Why might I be disclosing it? There's a lot of reasons to this day that people still feel very uncomfortable disclosing. A lot of it goes back to the history, that we started this conversation kind of reviewing, but you have a right under federal law to ask for an accommodation if you need it for equal access. And so in the workplace setting, as soon as an employer posts a job for anyone's consideration, the ADA is going to apply to them. And you would have the right to say, I need an accommodation to apply for this job. I need an accommodation to interview for this job, right? And then if you're hired, you'd have the right to ask for an accommodation to do the job duties. You'd also have a right to ask for an accommodation for any job-related travel or event or any job-related requirement that you would have to do, right? People, I think, are more comfortable disclosing apparent disabilities than non-apparent disabilities. And I think a lot of that has to do with society and how society perceives disability. I think generally speaking, and this is a huge generalization, people seem to be more comfortable with people that have an obvious impairment, right? Someone who uses a wheelchair, someone who's blind, someone who's deaf. I think people understand those types of disabilities. I think it's very hard when people see someone that they perceive to not have any disabilities, and then they learn they have a disability. I don't think we know as a society know how to handle that. No one teaches us how to discuss that, how to support people that have mental health or other non-apparent disabilities, right? We say all kinds of things that people mean to be supportive that are really hugely offensive when we find out. So that continues to be a really a large issue. But so I would say if you're thinking about disclosing disability, think about why might you want to do that? What are the benefits? What are the potential cons? The law gives you the freedom to decide if you're going to do that or not. And then if you want to disclose because you need an accommodation, keep in mind, you don't need to give them your entire medical or disability history. It's something extremely narrow. You just have to provide enough information that allows whoever you're asking the accommodation from that says, oh yes, this person does meet the definition based on this documentation. So it's not a lot of information you have to share. We'll keep going. And whatever you share has to be kept confidential, right? So this is kind of a summary of what the ADA says, that information about an employee or a student's reasonable accommodation request and any medical or disability information has to be kept confidential. It has to also be kept separate from that individual's personnel records or student records, right? The person who in the organization makes the decision to approve or not approve the accommodation, of course, knows about the accommodation request. Sometimes it's a supervisor or sometimes it's a manager. There are some very rare situations where the person who approves the accommodation isn't the immediate supervisor, and the immediate supervisor might need to know about the accommodations for it to be implemented. That's also okay. And then emergency treatment. So if you know someone has an accommodation because they have a seizure disorder, for example, and you have to call 911, you are required really to tell the responding people what you know, so that person can get the health care that they need. Do it as confidentially as you can, of course, but share that with them. And then government officials that might be investigating compliance or a complaint. And that's it. That's the only time that confidentiality can be broken when it comes to the ADA request. We'll keep going.
I have a We have had some students, they have gone through the process with the disability services, they've given the proof and gotten the accommodations, et cetera.
Yeah.
And sometimes they have professors ask them, like, what condition do you have?
I know.
Yeah, they're not required to respond to that, yeah,
No, and you should make sure they tell back the office
okay.
who's helping them, because no, they cannot ask that. First of all, the faculty should not be asking the
Mhm.
student that, but the faculty don't know, probably. So yes, someone from the Office for Students with Disabilities should do some education
Yeah.
with those faculty members, but yeah,
Okay.
they would not be required to answer that, and I know that's hard.
Mhm.
Because you're a student, and that's the faculty, you're gonna answer, but no, you're not required to answer that.
Okay.
Okay, did I finish everything on that
I,
slide before I go? Yeah, I did.
so, yeah,
Okay, so this kind of goes to your earlier question about caring for a child. This is as a student, who's not working, you would not have any protections under FMLA, which stands for Family Medical Leave Act. But people often get confused about the differences between the ADA and FMLA when it comes to leave and who can have leave and who's protected under leave. So I just thought I'd do a little comparison for everybody. So Title I of the ADA is employment related. It is leave as an accommodation for the person, the employee, right, with the disability. And there is no minimum or maximum period of leave that you can ask for. There's some case law that says really anything more than 6 months of leave probably is not reasonable,
Mhm.
but it's a little bit more open-ended. Under the FMLA, there are very specific requirements of when you're eligible. So you, generally speaking, have to work about a year before you've worked enough hours to be eligible under FMLA. The employer that you work for has to have 50 or more employees. But if you meet both of those, let's say you've worked there 2 years and your son is ill and you need to take some time to care for him or take him to healthcare appointments, you can ask for up to 12 weeks of unpaid job protected leave by going through the FMLA process of your employer, which protects your job, right? So it can either be 12 weeks consistently, or it could be, I need, a week every month until you run out. So it's a total of 480 hours, essentially. The main difference between those two, if you're ever trying to decide which is better for you, so FMLA could be for you, for your serious health condition, or a family member or someone that lives with you that you need to take time off to care for. That process is an extremely strong employer right. You don't have to ask really for permission. You just fill out the form. The doctor has to certify that you need this leave. And barring some very unusual circumstances, your employer has to approve it. There is no interactive process like there is under the ADA where you submit a request, it's considered, the employer might say, well, I can't do this, but I can do this, right? None of that in the FMLA. You turn in the right documentation, you're eligible, and you're going to get the leave that you need for you or for somebody else. Okay, let's keep going. So this is the job accommodation network resources. The first one, it's called JAM for short. This is a really, really great site. If you haven't seen it already, it allows you to search by impairment or medical condition, and it will give you a summary of different kinds of disabilities and how that disability may impact a person in like a lot of range of ways, and possible accommodations that might be helpful. Sorry, forget about the Disability Rights Oregon. That's from you can look at that, but that's essentially our organization. That should be Disability Rights Iowa. So look to us because we're here. We can help you. We have a national affiliate, National Disability Rights Network. That's our national organization. They provide resources and training. And then the ADA National Network and Regional Centers does a lot of really great work with all things related to the ADA and has great resources. Let's keep going. And I feel like we've covered all that. Let's keep going. Okay, so impact of ADA in higher education. Kind of wanted to break this down and have it be more specific than just kind of the general stuff. So what you're able to have as a protection in higher ed because of the ADA is equal access to academics. So the ability to ask for an accommodation, right? For academics and for employment, and program access. So program access is actually what it sounds like. It's access to the building, access to the program that's occurring. So an example might be, this building is not a good example of this because it's so universally accessible. But let's
Yes.
pretend we're in a building that has no elevator, right? And it's 3 stories, and you have a class on the 3rd floor. The only way to get there is stairs. The person, let's say they even have a temporary disability. Let's say they fell and broke their leg. They no longer can get up the steps. The program, they cannot get access to the program, which is that class. What would be required is for the class to be relocated to the 1st floor or somewhere that is accessible. That's program access. The accommodation to academics is doing something differently with the academics, changing maybe how a test is given, the time, the location, changing how the person's receiving the material, right? So it's not the actual physical building or the program, it's how you're learning, what you need to do, what you need to be able to learn that material. You also have the right to ask for an employment accommodation. So if you are a student working and you're earning $1 or a penny, you're considered an employee. Under the ADA, you can ask for an accommodation. IT accessibility, so all public facing websites should be accessible to people with disabilities. And I've given you an example there of a policy that I wrote in my last job that kind of explains what that means. But essentially, if you're a student with a disability or an employee with a disability and you're getting onto a computer, the public facing part of that computer should be accessible to you. So if you're blind and you use a screen reader, it should be accessible too. I will tell you, most websites are not accessible, including some of the state websites, the state agency websites. So I don't know about Drake. I've not ever tested Drake, but you can test and see if it's accessible. That's something that Drake and all campuses should be testing regularly and making sure that they're accessible. Event accessibility. So your question from earlier, can you ask for an accommodation to attend an event? The answer is yes. The ADA requires that you have the access to know who you have to ask, because most times you don't know, right, when you're going to an event. So the ADA says for all events, there should be a notice for who to ask for an accommodation, and then you should have the right to be able to ask for an accommodation to attend that event. The ADA does not require certain things to be provided proactively. I really disagree with this, and we do events differently in our office. But like, for example, 2 of the most common accommodations that are asked for are ASL, American Sign Language, and real-time captioning. We provide those proactively when we do events. Most events don't provide those because they cost money, right? But as a person with a disability, if you need one of those accommodations to be able to have equal access to the event, you should have the right to ask for that accommodation. The issue I have with that is that nobody knows, I think, what you want to do when you wake up, right? So to ask for an ASL accommodation, you have to ask 2 weeks before the event, right? I don't know about you, but I don't know. Do I know right now what I want to do 2 weeks from now? I don't know. I don't even know if I know when I wake up that morning. I might know when I'm going to the event. Oh yeah, this might be fun, right? So I don't like that. I don't think that's very accessible, but that's all the AD requires is have a notice of how to ask for an accommodation. If somebody asks for it, to the extent that you can, provide an accommodation, right? Unless it's a fundamental alteration or undue burden for that event sponsor to provide it. Most events are things that, you know, they don't think about accommodation, so they don't plan and set money aside. So if somebody asks for something that costs money, most event providers do not know what to do with that and will not probably provide it, but they should have a process. So for you, like to attend a school-related event, I mean, if it's completely like not a required academic one, but it's a school-sponsored event, you should have the same right to ask for an accommodation and have it be provided.
Okay.
The accommodation that someone asks for, though, one thing that's important to know is you don't necessarily get exactly what you ask for, right? Even regardless of what, why you're asking for an accommodation. So if you ask for, let's say ASL to attend an event and the event can't afford it or can't find one, sometimes that happens. What the event has to do is try and find something that would allow that person to have equal access to that material, right? Sometimes it might be notes back and forth, maybe captioning, but probably unlikely because captioning and ASL are not the same language, right? So, but you would try and figure out, is there something that can be provided that allows that person to have equal access to our content? Hopefully you can. If you can't, then that is potentially a violation of that person's rights under the ADA, depending on if they followed the right time frame and asked for an accommodation timely. Accessible seating. So that's the one other thing I wanted to say. Oh yes, accessible seating, accessible ticketing. So for both any kind of event that you want to have, like a sporting event, a theater event, a play, there has to be ADA seats available. Depending on how large the venue is, determines how many seats have to be available. And you have to have the ticketing process be accessible also to people with disabilities. Service animals we talked about. A service animal is only a dog, and in some small cases, very unique cases, a miniature horse that's been individually trained to perform a work or task for a person with a disability. Now, I have never seen a miniature horse. I know they exist. I would love to meet someone that has one someday. But for all practical purposes, a service animal is a dog, right? There's no requirement that the dog go to professional service animal training or wear a certificate or any of the things that people generally associate with having a service animal. Oftentimes, the person with a disability will train the service animal themselves, completely fine under the ADA. And they can go with their handler, which is what the term is for the person with a disability in service animal language, anywhere the public is invited to go. Okay. There's a few exceptions, like the service animal can come with you to the hospital, can be with you in the ER, can be with you in the recovery room, cannot go with you into the operating room, right? So if you think about kind of health and safety issues, that's where service animals can be denied entry. The standards for accessible design. So this building really completely exceeds any requirements, right? But other new buildings that are built on campus or substantial renovations of a building on campus have to comply with the new standards. The assistive listening systems and assembly areas, this is looping. I don't know, do you have any looping in this building? Anybody know? No. So your space is too small, or maybe the auditorium would have looping, but looping is a really amazing system. It's the best way to bring assisted listening to people that wear hearing aids. And you'll know if a room has it because there should be on either side of these doors. If we had it, there'd be like a little ear, a little hearing like that. And then all you have to do, and this is kind of old school, but it used to be you had to turn your hearing aid to a certain setting to be able to hear. And the looping, generally speaking, is in the floor and then attached to the microphones. And it brings all of the sound in the room directly into the hearing aid. And so I think that this, I think it's still considered state of the art for assisted amplification. But with all of the new Wi-Fi and Bluetooth and things that are happening, I'm guessing this will quickly fade, not be quite the state of the art. But right now it is great, and it is required in larger auditorium settings. The procurement laws. Now, as a student, you wouldn't necessarily know this, but universities are required to think about accessibility when they're buying things, right? So software products and other kinds of services, IT services, have to meet accessibility standards before they're bought. That's a procurement law. And so there's a whole technical way to test to make sure that what you're buying is accessible. So a university should have a kind of a plan or a policy in place that requires before you buy something, that it's tested and proved to be accessible. We'll keep going. So this is 508. This is where it requires that. And so section 508 applies to really web-based information communication technology, websites, documents, printers, desktop, mobile software, et cetera. It's really broad. And so one of the things that I think people don't think about is a lot of the libraries now on campus have volumes and volumes of older documents that they store digitally. Most of those are not accessible, right? And so how do you make those accessible? And what's the process for that? That is kind of, I think, unknown, and it's different by universities, but that is something that as a student, like if you need to go into the digital files and let's say you need to have that document be accessible to you, odds are it's not going to be unless, because it requires the university going back and getting that document and making the document accessible, because documents were not made to be accessible back, until very recently. So that is another issue that kind of comes up. We'll keep going. So web content accessibility. So this is kind of technical, especially on the end of the day on a Friday here, but this is, if you have any IT knowledge, this might make more sense to you, but this is what the web content accessibility guidelines require for web accessibility, right? So it's the content has to be operable. So the content cannot require an interaction with the user that the user cannot perform. So you're using touchscreen. If you had a mouse, the mouse would need to be, well, I should take it back. If you were not able to use a touch screen or a mouse, you would have to have the ability to interact with your computer in a way that's accessible to you. So that's content, right? Content has to be understandable. Users must be able to understand the information as well as operate the user interface. Has to be robust enough to be integrated, relied by a variety of users. So they have to meet each one of those. When it's fulfilled in each of its principles, it's considered accessible. So I know that means nothing probably to most people, but there's a test that you can use on each one of those standards to see if the web is meeting those standards. Okay, let's keep going. And that's an example of a policy on trying to ensure that this was the University of Kansas's website was meeting the WCAG requirements. Okay, now I just want to make sure I went through all these. So these are Title II and Title III of the ADA, how it impacts you here as a student. Title I is employment. So if you're working as a student, Title I would also apply, but requires physical accessibility, through buildings, on campus, requires academic access and the ability to ask for accommodations, ability to access a program, the IT, the web has to be accessible, the events have to be accessible, right? Ticketing, seating have to be accessible. You can bring a service animal with you to any public place here. New designs new buildings also have to meet the standards and the listening systems. So I think we covered all of that. I think I might have a slide. Yeah, I do. Okay, so I think I'm nearing the end.
Yeah.
Are we okay on time?
Uh-huh.
Okay. So a service animal, I think I already said this, but it's really a dog individually trained to do work or perform tasks for an individual with a disability. The tasks are related to the individual's disability. And then there's the ADA site if you're interested. So work or task, what exactly does that mean? So it's trained to take a specific action kind of when it is needed to do so for that person with a disability. So these are some examples that people don't often know that dogs can do. So you can train a service dog to alert an individual that has diabetes when their blood sugar is reaching either too high or too low level. The dog has the ability to smell your breath and know when you're reaching that. You can train a service animal to remind someone with depression to take medication. This really allows someone to live independently without that animal. They might have to have someone come in and help them remember to take that, or it might need to be in an institution, right, for that level of care. Service animal can be trained to detect the onset of a seizure and help that individual with the seizure remain safe. So they can alert the person, make the person sit down if they're standing, right, to kind of protect them from falling. Requirements of a service animal have to follow all of the local dog licensing, vaccination, and registration requirements. They have to be under the control of the handler at all times. And the service animal is 100% the responsibility of the individual with the disability. So under control essentially means that the service animal is either leashed, harnessed, or tethered to the person with a disability, unless doing so would not allow the service animal to do the work or task that they've been trained to do, or the person with a disability, because of their disability, cannot have that. And in that case, the service animal has to be under either a voice or signal or other means of communication to remain in control of the dog, right? Service animals are truly amazing. They are animals that are not going to be barking. They're not going to be jumping up on people. They do not have accidents in spaces. They do not grab food. Typically, if you had a service animal here that would be underneath this table, probably, you wouldn't even know the animal's here, right? So the service animal would be able to come with the individual with a disability to all parts of the school where the public is allowed or where programs are allowed. Things you cannot ask. You cannot ask for documentation of disability. Like, let's say you're out and someone has an animal. I'll just use this as an example because people have very strongly held opinions about this. Small animal in a baby doll carriage wearing baby doll clothing, right? I think the assumption is that can't possibly be a service animal. Maybe, maybe not, but we don't know. But what you cannot do is you cannot go up to that person and say, hey, where's your documentation of disability? Show me proof that your dog was trained. What were they trained? Show me how your dog does things, right? Tell me more about what this animal does. You can't ask any of those questions. So keep going. You cannot require registration of a service animal, and you cannot restrict a service animal to only certain breeds of dogs. A lot of cities try and do this. They'll say pit bulls cannot be service animals. Pit bulls are not allowed, period, right? In the county, cannot restrict that if it's a service animal. So what can you do? Same small dog in the baby doll carriage with the baby doll clothing. You can ask, is that dog a service animal and required because of a disability? Person says, no, they're not going to be a service animal. You can ask the person to leave with the animal. If the person said yes, you can then say, well, what work or task has the dog been trained to perform? And let's say this person says, well, my dog has been trained to alert me to a seizure. Okay, they're a service animal. Do not ask any more questions. Let the person go about their way with the animal. Anything else would be a violation of that person's rights under the ADA. Let's keep going. Oh, that's it. I didn't realize I was done. Okay, any questions?